adjunct professor at the Roger Williams University School of Law for many years, and I've performed as a performance judge for the Legal Education Partnership for over 21 years. My practice of 28 years focuses on domestic relations and child advocacy, and I've long been committed to helping make the family court system friendlier and more responsive to lesbian and gay couples and families. I'm not speaking to you this evening in my capacity as the president of the Rhode Island Bar Association. I'm speaking to you tonight in my capacity as a lawyer, a taxpayer, a constituent, and an oppressed, discriminated against citizen. Over the years, there have been small but significant developments in the law that have given families formed by same-sex couples some discrete and minor measures of protection. I can help my clients develop partnership agreements and sign papers that set forth their intentions about their financial matters, decision-making about their medical issues, and address what happens if one of them should die. I've worked with couples to solidify their parent-child relationships between both adults and the children that they brought into their family through second-parent adoptions. Clients spend thousands of dollars on wills, estate planning, relationship agreements, powers of attorney, adoptions, and other documents, trying to plan for every eventuality, every tragedy, every mundane circumstance when the legitimacy of their lives that they've built together can be called into question. These protections are critically important, but no matter how many or what safety nets I try to help them put into place, there is simply no way to provide them with the full scope of protections that would automatically receive if we were able to marry. Even for those couples who I can help take these steps, there's no way for them to contract into being able to take a leave of absence to care for each other in case of sicknesses, into workers' compensation benefits if one of them is killed or injured on the job, or out of having to testify about private conversations that they've had. There's no way that I can access to them the hundreds of protections available at the state level or the 1,300 protections available at the federal level for married couples and surviving spouses. And while joint adoption allows parents to have a legal bond with their children, gay and lesbian parents remain legal strangers to one another. A child conceived during a marriage in the state of Rhode Island is deemed a child of that marriage. Heterosexual couples routinely in this state conceive children via artificial insemination. Heterosexual couples who conceive children via artificial insemination have to take no further steps. That child is a child of their marriage. This is not true for gay and lesbian couples who conceive children via artificial insemination. Because we cannot marry, gay and lesbian couples must incur enormous financial expense and emotional stress of having the second parent adopt the child. Even though there are no other people who intend to raise these children who are conceived via artificial insemination, gay and lesbian couples have to go through the invasion of privacy. The biological parents have to have a criminal background check. They have to have a 6-month waiting period, a home study, and an adoption hearing. In another devastating manner, these lack of protections come into sharp focus when a client comes to me after his or her relationship comes to an end. There is the large group of people in this state that have legally married a same-sex spouse in another jurisdiction. They cannot access the Rhode Island Family Court, the court in their home state, to obtain a divorce. These are the group of clients whose relationships have come to an end after many years of joint decisions about their finances, their property, and their respective roles in building a life together, who now have to rely on a contract theory and a petition to partition, which are legal processes more appropriate to a business dissolution than the end of an intimate and economically intertwined relationship. Partition cases and contract cases do not allow for alimony or for an equitable distribution of assets that were acquired during their relationship. Despite the fact that these two adults had built a life together, the law ignores that reality. 28 years of practice in this area has starkly illustrated the manifest injustice of excluding loving, committed same-sex couples from the host of protections that only marriage can provide. Denying couples access to the comprehensive legal status of marriage simply because they include 2 men or 2 women only is utterly inconsistent with the promises of liberty and equality in the Rhode Island Constitution. As the Rhode Island Supreme Court has noted, Article 1, Section 2, quote, proscribes governmental action which treats one class of people less favorably than others similarly situated. This is the case of Parati versus Solomon, 657 Atlantic 2nd, 1045, Rhode Island, 1995. This exclusion of allowing gay and lesbians to marry, barring couples, same-sex couples, from access to a legal institution of critical, practical, and social significance, and branding their relationships and their families as second-class citizens, does exactly that. By contrast, ending the exclusion of same-sex couples from marriage is the logical extension of the Rhode Island Supreme Court recognition that a marriage, as a legal matter, has evolved from its history as an institution with inherent legal disparities between men and women into a partnership of 2 equals. This is the case of Landmark Medical Center versus Gauthier, 635 Atlantic 2nd, 1145. Now is the time for this body to take that next step, to extend equal protection of our laws to the thousands of same-sex couples in Rhode Island who are looking for you to treat their relationships with the dignity and respect accorded to all other intimate partnerships of 2 equals. We are your mothers, your fathers, your brothers, your sisters. We are your neighbors, your teachers, your doctors, your lawyers, your friends, and your colleagues. We are the same as you, without the same rights. We are seeking to be treated just like you, to have the same rights and responsibilities that you have. On behalf of my clients, my family of 30 years, and all of the same-sex couples in need of the protections and legitimacy that only marriage can provide, I urge you to vote in favor of House Bill 5012. Thank you.